Thank you for watching Kelly Longtin Law's YouTube channel. Today we're going to talk about using assisted reproductive technology and what happens to that unused genetic material when you pass away. When you think about how you want your property to be distributed after your death, most of the time it's easy to identify that property, like your home or your cars or your jewelry, etc., and things of that nature. But what about the genetic material that's used in assisted reproductive technology such as frozen sperm and eggs and embryos? And is genetic material stored with your doctor or a fertility treatment center considered property that needs to be planned for as part of your estate? Because of the high likelihood that frozen genetic material may survive the person who froze it, there's many questions that arise, such as who owns the genetic material after the person's death, who can use the genetic material after this person has passed away, and can a child conceived after the person's death inherit from their deceased parents? Now, some controversy exists about whether a frozen fertilized egg or embryo is human life. Some people believe that life begins at fertilization, while others believe that a frozen embryo is not human because it cannot develop into a fetus outside of the uterus. While state laws vary, most states consider frozen embryos to be property, but at least one state that I can think of, Louisiana, considers embryos judicial persons who can sue and be sued and affirms that an embryo cannot be intentionally destroyed. Now in Arizona, the law gives a party wishing to use a frozen embryo for reproduction purposes decision-making authority in any conflict over how that embryo is to be used. Now, when a person dies and leaves behind frozen sperm or eggs or embryos, who owns the genetic material after the person's death and who can use it? While the answers vary from state to state, in general, there's a distinction between who owns and controls gametes, meaning eggs or sperms, as opposed to embryos. Your sperm or eggs are generally considered your own individual property, and therefore your intent as to how these are to be used controls their disposition after your death. So if you intend to allow your frozen genetic material to be used for reproduction after your death, you should make your intent clear in your estate plan. Now, state laws that address the issue of embryos vary substantially. As I mentioned, in Louisiana, an embryo is considered a legal person and cannot be intentionally destroyed. In Florida, however, any written agreement controls the disposition of the frozen genetic material. In the absence of an agreement, the person who provided the gametes control their disposition, whereas a couple jointly decides the disposition of their embryo. If one member of the couple dies, the surviving member makes all the decisions about the embryo's disposition. Now, if you signed an agreement with the doctor or the fertility treatment center storing your genetic material, this agreement probably details what will happen to your genetic material at your death. For example, the agreement may state that in the event of both you and your partner's deaths, your frozen genetic material will be discarded. If only one of you dies, you may also have the options of either preserving the frozen genetic material and letting the survivor partner decide what to do with it or donating it to an infertile couple, in addition to the option of also disposing of it. Either way, there is some debate about whether such agreements are legally enforceable. So regardless of whether you have signed an agreement with the treatment center, it is important first to have a detailed discussion with your significant other about what you want to happen to your genetic material after you pass away. And then you want to memorialize it as part of your estate plan and make sure that the agreement and your estate plan line up. Given that frozen embryos can be safely preserved for decades, another question that arises with frozen genetic material is whether a child conceived after a parent's death is entitled to inherit from the deceased parent. Prior to the advances in reproductive technology, most state laws allowed a child born within 10 months of their parents' death to inherit, and children born after that time were usually excluded. In the last few years, state legislatures have begun enacting laws that deal more specifically with the issues raised by new technologies. For example, as of 2021, 11 states had adopted a version of the Uniform Parentage Act, which provides that if the deceased person consented to being the parent of a child resulting from assisted reproduction after their death, the deceased person is considered the child's parent. If you choose to provide for your afterborn children, it is critical that you make this wish known in your estate plan. Also, if you choose to provide for afterborn children, other questions arise about how you will provide for them. For example, will any afterborn children inherit equally with the children born during your lifetime? And if so, will you purchase life insurance with this purpose in mind, or allocate some of your assets to be set apart and held for any afterborn children? Because so many serious questions surround genetic material and its use after a person's death, it is important to consult with an experienced attorney who knows your state's genetic material laws and can competently advise you on how those laws affect you and your estate plan. I want to thank you for watching, and please feel free to subscribe to our YouTube channel so you can keep up to date on estate planning and various topics to help you better understand estate planning and how it can benefit your family. I'm Kelly Longtin, founder of Kelly Longtin Law, and I will see you next time.